Hello everyone, I Vijay Chittiboina has come before you with this video titled Attack on Judiciary, which has got lot of importance in the current situation of ongoing tussle between the government and the judiciary and the recent continuous attacks on the apex court in the last few months in the form of public statements, interviews, tweets, writing letters and sharing video clip by the people holding key positions from the government side over the appointment of judges of Supreme Court and High Court and transfers. Through this video, I would like to clear the misconception of the common man on the widely propagated notion that judges appointing judges. For this, we need to understand the collegium system, NJAC, basic structure doctrine, constitutional supremacy, and the importance of independent judiciary, and know what will be the possible danger if the government has a final say in the appointment of judges. In this process, we will go through the comments of few elites on the controversy and come to a sound understanding after clear analysis. First, we will start with the collegium system. Up to 1973, the President appointed the Chief Justice of India and remaining judges of the Supreme Court in consultation with the CJI and other judges as deemed necessary. A petition was filed in 1982 in the Supreme Court, which is known as the SP Gupta case or First Judge's case. The question came before the court is whether the word consultation in the Constitution Article 124 mean concurrence. The Supreme Court denied, saying that consultation does not mean concurrence. Here, the President was not bound to make a decision based on the consultation of the Supreme Court. Another petition was filed in 1993 before the Supreme Court by the Advocates on Records Association. In this case, the Supreme Court overruled its earlier verdict and changed the meaning of consultation to concurrence, thus binding the President of India with the consultations of the CJI. This resulted in the birth of collegium system. Again in 1998, the presidential reference to the Supreme Court was issued questioning the meaning of the word consultation in Articles 124, 217 and 222 of the Constitution. Here the Chief Justice won't be the only one as a part of consultation process. Consultation would include a collegium of 4 senior most judges of the Supreme Court. In this, the Supreme Court laid down strict guidelines for the appointment of judges of the Supreme Court and High Courts, which is currently known as the collegium system. There are certain concerns raised in the collegium system of appointments like exclusion of executive, where the collegium are not accountable to any administrative body that may lead to the wrong choice of the candidate while overlooking the right candidate, and chances of favoritism and nepotism, as the collegium system does not provide any specific criteria for testing the candidate for the post of CJI, because of which it may lead to wide scope for nepotism and favoritism. It is politically criticized that the system is against the principle of checks and balances, where the collegium system gives judiciary immense power which leaves little room for checks, and this may pose the risk of misuse. One of the criticism is closed door mechanism. The collegium system does not involve any official secretariat. It is seen as a closed door affair with no public knowledge of how and when a collegium meets and how it takes its decision. The other concern is unequal representation, where SC, ST, women are underrepresented in the higher judiciary. I deny this, as recently the Supreme Court Collegium recommended 192 candidates for the High Courts. Out of these, 37, that is 19%, are women. The collegium system faced some criticism from the government and the civil society, which led to the 99th constitutional amendment bringing the NJAC Act to replace the collegium system for the appointment of judges. This is an act to regulate the procedure to be followed by the NJAC for recommending persons for appointment as the CJI and other judges of the Supreme Court and Chief Justices and other judges of High Courts, and for their transfers. There exists a veto power regulation which empowers any two members of the commission to disapprove of any name, and the NJC would not recommend that judge. Let's see the arguments in support of NJAC. This act claims to end the opaque mechanism and ensures transparency and accountability within the collegium system. This act may bring integrity between the judiciary and executive and makes it all inclusive. And the involvement of the government and people from other backgrounds can make the appointment more diverse and with a real perspective. Issues of minorities, SCs, STs, and women will also be given preference. It can also lead to more women judges in the higher decision making system. The NJAC Act has been struck down by the Constitutional Bench in 4:1 majority, rejecting the NJAC Act and the constitutional amendment as unconstitutional and void. It held that the collegium system as it existed before the NJAC would again become operative. But interestingly, the bench admitted that all is not well even with the collegium system of judges appointing judges, and that the time is ripe to improve the 21-year-old system of judicial appointments. Justice Kehar told the government that there should be further debate on bettering the working of the collegium system. While Justice Lokur, Justice Kurian, Justice Goyal agreed with the Justice Kehar's nearly 500-page order on merits that the NJAC and the constitutional amendment defeated the primacy of judiciary over the government in the appointment of judges. Justice Chalameshwar differed, saying that the judiciary cannot be the only constitutional organ capable of protecting the liberties of the people. Let's see the reasons for striking down the NJAC. Risk being caught in a web of indebtedness towards the government is the first reason, and the wisdom of appointment of judges cannot be shared with the political executive, where the organic development of the civil society has not as yet sufficiently evolved in India. This is also one of the reason. And other reason would be the reciprocity and feelings of payback to the political executive would be disastrous to the independence of the judiciary, where government is a major litigant in high courts. So this feeling of reciprocity may lead to disastrous consequences. Since the executive has such a major stake in majority of the cases which arise the consideration before the higher judiciary, the participation of the union minister in charge of law and justice and an ex officio member of the NJAC would be clearly questionable. Grant of veto power to eminent persons under the NJAC Act amounted to conferring them with monarchical power, as they could then cripple the decision of the president as well as the CJI regarding appointment of a judge. A review petition has been filed in 2015 in the Supreme Court on judgment which struck down the NJAC. The Constitution Bench, comprising Justice Lokar, Justice Joseph, Justice Kanvilkar, and Justice Ashok Bhushan, dismissed the review petition on the ground of delay of 470 days in filing and found no merits in the petition. Recently, Supreme Court agrees to hear petition to reconsider the collegium system and resurrect NJAC. Chief Justice Justice Chandrachud agreed to hear the petition which sought the reinstatement of NJAC, which briefly gave the government equal status with the judiciary. The Vice President has also joined the Law Minister in needling the Supreme Court in recent months. He termed the 1973 landmark Kesavananda Bharati case verdict, which gave the basic structure doctrine of the Constitution, as bad precedent. He wondered if a constitutional amendment unanimously passed by Parliament reflecting the will of the people could be undone by the Supreme Court. Chidambaram, a politician, senior lawyer, and the former finance minister, opposed the vice president's remarks and stated that the parliament is not supreme and it is the constitution which is supreme. The striking down of one act does not mean that the basic structure doctrine is wrong. In fact, the vice president's views should warn every constitution loving citizens to be alert to the dangers ahead. The present Union Law Minister Kiran Rijiju labels collegium system of appointing judges as opaque, not accountable, and alien to the Constitution. The Law Minister has written to the Chief Justice of India suggesting the inclusion of government representatives in the Supreme Court's collegium to infuse transparency into the process of appointing judges. If government wants a place in the collegium, that's not unreasonable, he states. Kapil Sibal, the former Union Law Minister, a senior lawyer and a politician, expressed disapproval of the present Law Minister Kiran Rijiju comments. Sibal labeled these attacks on the higher judiciary as an attempt to capture the last citadel of freedom and says collegium system better than government controlling judges appointment. Between the two any day he prefers the collegium system. Sibal asserted that the basic structure doctrine expressed in Keshavananda Bharati verdict was very important now and it is not flawed. The government has not adjusted to the fact that it does not have the final word on appointments in the higher judiciary and feel bitter about this. He added government is trying their best to create a situation in which the NJAC in yet another avatar. Jairam Ramesh, member of Rajya Sabha, an economist and a senior politician, reacted a day after Vice President insisted on parliamentary supremacy. He observed that all this is orchestrated confrontation with the judiciary to intimidate and thereafter capture it totally. The collegium needs reform, but what this government wants is complete subservience, and its remedy is a poison pill for the judiciary. Ex Chief Justice of India, Justice UU Lalit, defended the collegium system and said that the judiciary was better suited than the political executive to evaluate candidates for judgeship of constitutional courts. He stated that there is a complete transparency in the collegium system of appointment of judges. Harish Salve, former Solicitor General of India, differed with Justice Lalit. He found that no judiciary in the world appoints judges and the NJC judgment is flawed. Salve, being a critic of the collegium system, remarks that the established system is not working and mentioned that some of the finest in the Indian judiciary came from the system where the executive appointed the judges in the past. Ex-CJI Justice N.V. Ramana defended the collegium system, saying that the notion of judges appointing judges was a widely propagated myth. While both the judiciary and the executive branches are involved in the judges' appointments, the judiciary is just given priority. He expressed sadness to note that the well informed persons also propagate the aforesaid notion that judges are appointing judges. Upendra Bakshi, legal scholar, recipient of the Padma Shri, states that the collegium system is law of the land and the idea of absolute parliamentary sovereignty is erroneous and haunts the nation once again, which is long settled. If there is any sovereignty, it is sovereignty within the law and not beyond the law. He states that the safeguarding the rights of the citizens can only be ensured by keeping judiciary insulated and independent from the other organs of governance. It is a sad state that judiciary, the important pillar of democracy, is at danger. The present government has control over all public offices and if it captures the judiciary as well by appointing their own judges, it will be danger. The government want their own people everywhere. They have their own people at universities now. The vice chancellors are theirs. Governors in state are theirs. Less said about the election commission is better, as we all know. All public offices are controlled by them. They have their own people in the ED. They have their own people in the income tax. They have their own people in the CBI. Now they want their own judges too, which is their ulterior motive for all these strategic attacks. The attempts of the government to capture the judiciary must be resisted. It is inappropriate for anyone to make public statements. I think if anything needs to be done, the court should look at it on its own. The attacks on the judiciary were only one sided attacks. Comments or statements and any adverse remarks in this regard are only damaging the institutions. All statements made by the Supreme Court are in the court and there is no public statements made by judges. When it comes to the supremacy of the legislature versus judiciary, it is the constitution which is supreme. Our constitution has a system of checks and balances among the three wings legislature, executive, and judiciary. Each wing is supreme in its own sphere. At times, it seems one wing has encroached upon other's domain, leading to friction. In fact, a little friction is a sign of a working democracy and an independent judiciary. When it comes to collegium versus NJAC, it doesn't matter whether a cat is black or white as long it catches mice. In the same way, it doesn't matter whether it is a collegium system or NJAC as long it is providing the aimed justice. I am in an opinion that the present collegium system and independent judiciary is doing good, and the present government intervention in the judges' appointment is needless and would be a danger. In the present days of failing public institutions, people have some faith only in the judiciary after the three legs of democracy. The expectation from the judiciary to safeguard the rights of the citizens of this country can only be ensured by keeping the judiciary absolutely insulated and independent from the other organs of governance. Let's save independence of judiciary, save democracy, save people, salute constitution. Jai Hind.